I think are on the right track. So can people see those slides?
Yep.
Super.
Yep.
Right, we will get going then, folks. What I will also do, I'm conscious 2 hours is quite a long time for someone to be talking at you about public procurement law. So I will set an alarm and we'll have a comfort break at 11 o'clock. You can stretch your legs, or if you're anything like me, grab some caffeine, more caffeine. So yes, thanks very much, everybody, for coming back. This is the first in our, I think it's a 6-part series we're going to be running, looking at different elements of the Procurement Act. You can find more details of that on the Efficiency North website, and I'm sure we can put a link in the chat later if anybody's struggling to find that. I think we've generally got 2 a month, so the next one will be later this month. And you're very welcome to join. They are, of course, like this one, free of charge for Efficiency North members. My name, for anybody who hasn't attended any of our previous sessions, is Kieran McGahey. That's my LinkedIn profile. Some of you may recognize me from there. I'm posting incessantly on LinkedIn about public procurement law. So if you're not too bored by the sort of things we're looking at in this webinar series, welcome to connect on there. I'm based up here in Newcastle upon Tyne. I've done a lot of work with authorities, particularly in the north of England, as a solicitor. I also, over the past few years, have been delivering legal training, speaking at a lot of events, things like that, in particular with the introduction, obviously, of the new Procurement Act, delivering lots of training, helping people to hopefully get to grips with the new regime. So, be looking at today, as this session is really designed to be a bit of a refresher on the rules regarding frameworks, the new open frameworks, and also the new dynamic. So we're going to look to begin with some of the rise, and that will be a bit of a throwback also to things that risen under the previous regime, but I think will still be very relevant, because as we'll come on to in a moment, a lot of those contracts, framework agreements that were awarded under the previous regime will continue to be governed by that regime. So don't throw out your copy of PCR 2015 just yet. And we'll then move on to the new rules in terms of closed frameworks, or just frameworks. That the Act doesn't actually call them closed frameworks. That's just a term I think some people are differentiate between traditional framework and the new open framework. And again, we'll look at in a moment what an open framework is. And then also the dynamic market sees the success to purchasing system 2015. We'll then have a bit of a comparison table, and again, you'll get the slides and some of the key takeaways after the session. So there'll be a kind of comparison tool which might be helpful for you in deciding what's fit for us, what's going to be best for our particular procurement. There'll then be some practical tips for calling off a framework. So that's, that may be a CCS or a regional one, whatever it may be. There may be some tips for calling off, but then also be practical tips for setting up a framework. So if your council or housing association decide actually we're going to set up our own framework, either just for us to use or our neighbours to use, or as some sort of collaboration with other contracting authorities, etc., etc. And last but never least, there will be time for audience Q&A. So very welcome. We'll have some time for questions at the end. So very welcome folks to just put questions in the chat as we go through, and we can aim to up. And as I said, we will have a break, a comfort break at 11 o'clock. So up then, in terms of before we launch into what's new on the Procurement Act, as a lawyer, obviously, I think contracts are terribly exciting. So I just wanted to remind everybody what is the contractual structure of framework. So pardon the sketchy diagram. Just wanted, so this is intended to be a visual representation of how a framework would work. So we have right at the beginning, we have our framework start date, and right at the end, also in yellow, have our framework end date. So that could be, for example, 1st of January 2026, and the end date might be 31st of December 2030. We then, within the term of that framework, we then have individual call-offs. So that could be a call-off. That first call-off could be in February. That second call-off could be next summer. That third call-off could be the summer of the following year, etc., etc. And for some frameworks, there could be hundreds, loads of different call-offs. But the important thing, the point I really want to emphasize via this diagram is a framework results in lots of different individual contracts. So all of these little call-offs along the bottom, these are individual contracts. Indeed, depending on the framework structure, they may be contracts between different authorities and different suppliers. It will depend. Obviously, if it was a single supplier framework with only the contracting authority using it, these would all be between the same parties, but possibly not. So it's just something to bear in mind. We've got lots of different contracts in play. It's not one big contract. So we'll need that. That'll be something that comes into relevance when we look at things like contract and indeed contract management of the actual framework. So that's something we will come back to later. What are some of the issues then that arise at present with frameworks? As I say, when I'm not delivering legal training, I work as a solicitor. So these are some of the things, to be honest, that have came up in but also things that have just crossed my desk over the years that maybe don't always necessarily make it to court, but can be potentially problematic. So the first one is that framework value is reached or indeed exceeded, but authorities are still calling off the framework. Why is this a problem? This is potentially problematic, at least in light of some of the case law from Europe. There was a case, an Italian case a number of years ago. There was also a case, Simonson and Veil, which I think was Danish, possibly, somewhere in Scandinavia. And that was suggesting that if calling off a framework, so say, for instance, a framework is an estimated value of £10 million, and you put £10 million of spend through that framework, it was suggesting then the value is then exhausted in terms of being able to make compliant awards from that framework. So once you've reached the value, that's it. Can't make any further compliant awards from the framework. So that lends to potentially in terms of everybody just make sure they're on mute, please. Thank you. So that could just lead to potential issues if you weren't on top of the framework, or you're using someone else's framework and you weren't quite sure how much has been. Just something to be of. Call-off pricing is not in line with the framework pricing. There was the case of Consultant Connect a few an NHS procurement case. Some may be familiar with that case. If not, it's worth having a look at. Example of how not to run a procurement. It's not one I use in my training like this, but you had all sorts of shenanigans. There was a presentation stage, something that may gain traction under the Procurement Act. Bidders did not know they were actually being scored. Not a good start. But anyway, one of the issues that came up in this Consultant Connect case, and there were lots of issues, one of the issues came up relevant to today's session was that the judge said pricing board, the call-off pricing bore no resemblance to framework pricing. So if you are using a framework, you need to make sure the pricing is in line with the framework pricing. One of the telltale signs for this I've seen over the years is saying, "Oh yeah, we're set up for this call-off, finalizing the price." But well, how is finalizing the price? Is it not framework price? So yeah, that's one to keep an eye out in terms of pricing. Duke's bailiff's case or fit for purpose. The bailiff case this was a case a few years ago. I think it was involving a council regarding the procurement of their debt enforcement services. Now, it was found in the court case, the judgment, that these were actually concession services, because you may recall for a concession contract, there's a transfer of risk to the operator, and they may not recoup their operating costs, etc., etc. They're not guaranteed. That was found in these debt enforcement contracts. The difficulty was the terms were just standard framework agreement. So there wasn't actually any concession terms and conditions. And a concession contract, when we think about it, looks very different, needs to look very different, I would say, from a typical contract, because under a typical contract, you are paying a supplier. Under a concession contract, rather, sometimes they paying you, or at least if they're not paying you, they're getting paid by someone else. So you need to be very your call off terms reflect the actual reality. In particular, in that case, if it's a concession, then it needs a set of concession terms and conditions. Because if you look at that framework agreement, it probably suggests that the contracting authority had to pay the supplier. But as I understood it, the supplier was getting paid from the debtors, that it was pursuing for, the bailiff cases. Really important that you've got the right, really important to start to be able to spot a concession and know what is and isn't a concession. And that's helpful for that, but also to make sure the terms and conditions are fit for purpose, and also then just fit for purpose more generally. I have advised clients in the past when we've been calling off the framework and there have been mistakes and errors in the conditions. For example, it's cross-referencing clause 14 when it should be cross-referencing clause 15, and that's potentially problematic because it's maybe referencing termination rights or something like that. So really important that you are making sure those terms and conditions fit for purpose. I think there's sometimes a bit of as we'll come on to, I think there can be a bit of a lackadaisical approach to call-offs, but ultimately, these are still legally binding contracts in the same way as any other contract. Competitions not being conducted in line with the process set out in the framework agreement or the original tender documents. Yes, this is something that is problematic. Again, one of the cornerstones of public procurement law has typically been all about transparency, and you want to make sure you are doing things in a transparent fashion. We don't, under the Procurement Act, have an express of transparency, but it's still something that appears a lot in the guidance. The process of awarding public contracts must be transparent, is what some of the guidance says. And we've also got this new objective in section 12 of the Act about sharing information with suppliers, and that objective is something that we must have regard to the importance of, whatever that means. But anyway, yes, long story short, transparency hasn't gone away, would be my view. So do just make sure you are looking back at what did the framework say in terms of how contracts would be awarded, and how can we ensure we're awarding contracts in line with that. And it's very useful if you're setting up a framework to put together some sort of short user guide. For example, just telling people this is how you would need to run a mini, or if you would need to run a mini company, maybe times you can just make a direct award. So really helpful tools sometimes to have those user guides. Bidders trying to change contracts at the point of call off. Yes, this is a really important one. Not necessarily relevant to framework. I think you need to be very careful point in terms of the new guys setting rules under the Procurement Act, because if you had a call off from a framework, Procurement Act framework, that was worth over £5 million, you'd be into the rules about setting at least 3 KPIs. You then need to publish ratings against those KPIs at least annually. So I could see that being one where the bidders oh, that's great news that we're your preferred supplier. By the way, can we just go back and water down all those nasty KPIs that we were never confident of meeting? So do a good tip, I think, when you're setting your KPIs is make sure you're doing your pre-market engagement, make sure you're flushing out any issues at that early stage, and that you're using what they refer to as the SMART acronym for setting KPIs. And I'm going to try and see if I can remember that. So it's KPI should be specific, measurable, achievable, relevant, and time-bound. Specific, measurable, achievable, relevant, time-bound. SMART acronym, which can be quite useful when you are setting KPIs. But anyway, I'm getting off topic. Bidders trying to change contract terms at the point of call off. That could be KPIs. It could be anything. Just it could be quite often, I'm sure, things like liability caps, indemnities, intellectual property rights. Either way, do just keep an eye out for that. And it is potentially even more of a problem in future because of the obligation to publish contracts over £5 million. Because obviously, and again, this is of a general point, the one specific to frameworks is bear in mind that an aggrieved supplier who maybe lost the tender or lost the call off be able to see that the terms and conditions that you've entered into are not the terms and conditions that you went out to tender with, creating potential grounds for a claim if they could evidence, for example, that their price would have been lower, or they would have scored better had those terms and conditions applied from the outset. They may have said, well, if we knew there was less risk, we could have done a better price, etc., etc. So need to be very careful now about these sort of post-deadline negotiations. Other issues that arise at present: call-off order forms are completed without input checking by legal teams. Again, I think there's sometimes an overly relaxed attitude in my experience at times, as if it's a form filling exercise. This is a contract. If you're calling off, and I've been involved in call-offs worth tens of millions of pounds, so if that was a contract worth tens of millions of pounds, I'd imagine you'd be given that quite careful scrutiny. Whereas with order forms, it's sometimes seen as a bit of a formality. But when you actually delve into these order forms, it's not just innocent things like, customer name, supplier name. You're getting into things, as I mentioned, like liability caps, indemnities, can be termination rights, who's the data controller, who's the data processor, who owns the intellectual property rights. It can get into really legalistic technical matters. So do make sure, particularly for those higher value ones, that you have legal support if you're not sure. You've got access to that. To be honest, it's not a bad idea in the first place, just to be getting them ran past your legal team for just a bit of comfort, a second set of eyes. Misunderstanding RE contractual structure. Again, I've kind of touched upon that. Call-offs are separate individual contracts, and that can create potential issues around termination, novation, or if you are, for example, suspending a supplier from a framework. So you do need to bear in mind these are separate individual contracts, and again, we'll come back to that later. Losing bidders in a mini competition are not always provided with adequate reasons, and there was an OCS case in recent years that suggested that whilst under the previous rules there was no requirement to give losing bidders in a framework a competition a standstill letter, the level of detail was held to be pretty similar, to be honest, in terms of making sure you're providing reasons for your decision. General, public law expectation that contracting will be providing reasons. So do be careful. And we'll come on to that under the new rules, but I would make sure you're providing a sufficient level of detail in your mini comps. And that above case is part of an increasing trend of legal challenges to framework call-offs. Used to be a bit of a perception, which has now been proven to be a misconception, that frameworks were quite safe, and we'll just use a framework and it'll be fine. We can do what we want. But that's obviously not the case, and we are seeing over the years more and more framework awards being susceptible to legal challenge. Indeed, sometimes successful legal challenge, like the Consultant Connect case. This is just to confirm before we launch into the new rules. This is the transitional arrangements, and this is very, very important. Pardon the speech, I will fix that. So procurements commenced under the previous rules and contracts awarded under the previous rules will continue to be governed by the previous rules. I'll give you an example in a moment of how that will operate in practice. Procurements commenced under the new rules, contracts awarded under the new rules will be governed by the new rules. So that's really, folks, should be one of the starting points when you're using a framework. It's obviously, when you're setting up a framework, it's quite clear that's going to be under the new rules. But when you're using someone else's framework, that's one of the really, really key things that you need to ascertain right at the outset. Is this a PCR framework, or is this a Procurement Act framework? So this is a transitional arrangement work example. So CCS set up a 4-year framework agreement in 2023. Home Group want to call off the framework next month. In 2026, the provider asks Home Group to amend the specification in the call-off contract and also to give them a 10% price increase due to supply chain pressures. That request would need considered against the rules in Regulation 72 of the Public Contracts Regulations, not the Procurement Act. Why? Because if we look at the dates, the framework agreement was set up before the Procurement Act came into force. So even though Home Group, who are the customer in this case, are calling off now in the era of the Procurement Act, the framework was set up under the old rules. So that's really important. So if in that 2026 scenario, say it just happened to be your authority and your colleagues are coming to you, look, we've got a supplier, they want to amend the specification to change these things and they want a 10% price increase, you need to be finding out firstly, is this a PCR framework call-off or is this a Procurement Act framework call-off? Because that ultimately dictates which legal rules apply. So that is really important. One thing I've seen, which I think is quite helpful, is some organizations who operate frameworks have started to put on their, the sort of homepage or website or whatever it's called for the framework, we might say, this is a PCR 2015 framework, or this is a Procurement Act framework, start date, end date, etc., etc. So that can be a helpful thing to think about. The other thing I would encourage you to look at is if you have a contracts register, and you should look at color coding that, and also look at potential giving new frameworks, new contracts, also a reference number. So you could, for example, one authority suggested to me they were going to add the letters PA for the reference number, so people would then know in future this is a Procurement Act contract, whereas anything that didn't have PA would be attributable to the previous legal rules. Things to think about there in terms of little practical identifiers. But either way, whatever you're doing, make sure you are checking which set of legal rules apply. There is lots of applicable guidance for today's session. This is the, I think there's something like approximately 50 different guidance documents for the Procurement Act in general. So you're not going to be light on bedtime reading, but that's the guidance there on frameworks. That's the guidance on dynamic markets. As I say, you will get a copy of the slides. You can click through. Those are sort of clickable links. If you click on the icon, it will take you through. As I'll explain in a moment, I don't think dynamic markets will be terribly popular, but the guidance on frameworks is quite helpful in places, although there are other places that it kind of gives rise to as many questions as it does answers. So we'll have to wait and see if we can get some case law in due course to shine a light on some of those grey areas. But it is helpful, I think, as a starting point, at least to know what the guidance says, so you can access those. The real headline focus, I'm sure many of you will be aware, is the introduction of open frameworks under the Procurement Act. And we'll see in a moment how those operate, but is essentially they do as it says on the tin, they open periodically, although there are certain rules around how those openings take place. How is a framework defined under the Procurement Act then? A framework is defined as a contract between a contracting authority and one or more suppliers. So again, could be single supplier, could be 10 suppliers, could be 20 suppliers, which provides for the future award of contracts by a contracting authority to supplier or to a supplier or suppliers. So it's worth noting there, defined as a contract between a contracting authority. So a framework agreement is itself a contract, which is important to bear in mind in terms of references to the contracts under the Act and the obligations that are attracted by virtue of being a public contract. That definition is set out in section 45(2) of the Act, and a framework contract for goods, services and or works are to be awarded. What are some of the changes to previous rules? Well, the Act provides that conditions of participation, the artist known as selection criteria, can be applied as part of the for the award of a call-off. So that's potentially quite helpful. So for instance, you were using a framework, or you wanted to use a framework, but you weren't quite happy with the minimum financial turnover requirements or perhaps the insurance requirements, that were on the framework, in theory, you can potentially introduce your own requirements as part of your call-off process. The Act also implies a term into every framework that a contracting authority is permitted to exclude a supplier that becomes an excluded or excludable supplier from participating in any selection process. And that could be a selection process, could be a mini comp, or it could be a direct award. So just to recap then, excluded or excludable, this is new language around the exclusion grounds. Previously we had discretionary and mandatory exclusion grounds. So an excluded supplier means there is a mandatory exclusion ground applies. An excludable supplier means there is a discretionary exclusion ground. So you could exclude them, but you don't have to. So typically for breaches or things, which are serious but less serious than the mandatory grounds. So anyway, that if that comes up during the term of your framework, you can then, avoid working with them in future more easily, which I think is a good thing. So if, for example, you had a supplier and they were very naughty and they did something which was a mandatory exclusion ground, and you were running a mini competition next month, you could just say, sorry, you're not taking part. You're an excludable supplier under the Procurement Act. So that is potentially quite helpful, although hopefully you wouldn't need to do that, but it's there if you need it. Do remember that you now need to publish a contract award notice following the award of a call-off, but only where a contract award notice would be needed. So, for example, you don't need to publish a contract award notice for a below threshold call-off, because you don't need to publish a contract award notice for a below threshold procurement. But do keep in mind also that with regard to some of the notices for call-offs, like a contract detailed notice, there are the notifiable below threshold requirements, which for councils and housing associations is 30k. So that's something to keep in mind in terms of what notices you might need to publish for call-offs that are, say, for example, 50k or 60k. But if your call-off was, for example, just a relatively small one, 10, 15, 20k, you shouldn't have to publish any notices. But yes, do keep in mind that for above threshold call-offs, you need to publish a contract award notice, something that you didn't have to do under the previous regime. And remember, very confusing, contract award notice is now published before the contract is awarded, contract details post-award. The other thing to bear in mind is for frameworks under the Procurement Act, you can have a voluntary standstill period, but it's not mandatory. And remember, it's now an 8 working day standstill period, not the previous 10 calendar day, which sometimes can mean subtle differences in practice. So what I'm going to do now, folks, is go through some of the specific concepts and key principles for setting up or using frameworks under the Procurement Act. So I'm going to set out, for example, requirements. What are the sort of minimum ingredients essentially that framework must have? Things like price, things like the rules on debrief for liability sets, etc. So first up, then, the requirements for a valid framework. A framework must contain everything set out on that slide. So A, it must contain a description of the goods, services, or work to be provided under the contracts awarded in accordance with framework. Hopefully fairly simple. The price payable or a mechanism for determining the price payable. Interesting. We'll come back to that under such contracts. The estimated value of the framework, and again, bear in mind the point I raised earlier about the dangers of exceeding the contract value. Any selection process to be applied on the award of contracts. So that is, how the mini competitions might operate. The term of the framework, see section 47, that sets out the rules for, maximum length, etc., which we'll come on to. The contracting authority is entitled to award public contracts in accordance with the framework. So looking above then at the estimated value of the framework, that really ties in with that, folks. If you're setting up a framework and other people are going to use it, you need to be getting from them an idea of how much they envisage they might spend. So the contracting authorities entitled to award public contracts in accordance with the framework, then whether the framework is an open framework under section 49. What then about valuation of frameworks? The estimated value of the framework, i.e. all the call-offs, and remember I mentioned earlier, these are separate individual contracts, must be included in the tender notice, and the value cannot be exceeded. So like I mentioned earlier, that's potentially problematic if you have a framework that is estimated value is £10 million and £9.9 million of that has been spent, and you want to make a £2 million call off. That's potentially at least going to be problematic, although the rules contract variations could come in. But yeah, in principle, we just need to be very, very careful where you're approaching the framework value. Getting the right estimate is increasingly important. But yes, it may be possible to and either the estimated value of the framework or of an individual lot if that is being approached. And we will be looking at one of our other future sessions around issues around contract management and the rules on contract variations. But yes, and that was something also we looked at last year in our session on contract management and contract modification. There is potentially scope to change the framework value, but there will be limits on that. So I think I would encourage you to try to get it right, or as right as possible in the first instance, because the value cannot be exceeded subject to the rules on modifications. The other point to note on value is I see some very high in that case, but that doesn't really work because there are a number of problems with that. Is firstly, we obviously have the policy drive at the moment to bolster and improve, SME involvement in public procurement. So if you are saying your framework is worth 30 million, when in fact it's probably only worth 10 million, SMEs might look at that and think, no, that's not for us. That's too big. We couldn't really service that value. So that's one of the problems. The other then is that, say an SME does bid and they get on the contract, in a few years' time, they're looking at the spend and think, well, you didn't actually spend anywhere near 30 million. So that was a waste of our time. So yes, I don't think there's a problem in terms of maybe going a wee bit over what you think you might spend, but don't overinflate it just as a sort of, right, that'll help protect us under the procurement rules, because there will be other potential pitfalls, and it should really be a kind of genuine and reasonable estimate. But yeah, do think carefully how much you're going to spend, because once you're getting near that maximum, it is legally potentially problematic. You're using other people's frameworks, do check the spend to date, and that's something we'll look at later when we look at some practical tips for calling off. What about the fees then that can be charged for frameworks? And by this, I don't mean necessarily the price payable under the contracts. I mean the actual fees attributable to the framework operator. They can only be charged to suppliers that have been awarded a call-off contract. So essentially, folks, it must be a success fee. You cannot just say to supplier, right, if you're going to be on our framework, you're going to have to pay us X amount every month or every year, whatever it may be. You can only charge them if they win. So it operates essentially as a success fee. It must be set as a fixed percentage of the estimated value of the call-off contract. You couldn't say, for example, right, you have to pay us, 2K for every contract you win, or give us a 5K rebate, etc., etc. Must be set as a fixed percentage of the estimated value. The fees may not change during the lifetime of the framework. You can't decide, right, this is great, lots of people are using our framework, we're going to bump up the fees. Can't be done. To change charge suppliers rather to gain access to a framework, or any other fees associated with the management of the framework. So again, quite clear on this, quite emphatic. It can only be a success fee that you charge suppliers, and those fees can only be charged if the details are set out in the framework and the tender or transparency notice, and that's from the procurement regulations 2024, those references. The tender notice, to recap, that's the main notice under the Act where you advertise your procurement. The transparency notice is where you advertise a direct award. I think it's very unlikely you're going to be awarding a framework by a direct award, but just something to keep in mind in that unusual scenario that you have to set out the fees. And if you don't, then you're on shaky ground legally to be charging them. We don't want that. Length then, how long can your framework be? For councils, housing associations, which I think probably make up the bulk of today's audience, the maximum term of a framework is generally 4 years. Although, as we'll see later, there are special, more relaxed rules for light touch frameworks, things like, social care, education, certain legal services, etc., are not caught by that general 4-year rule. But for most things that we're buying, the maximum term is generally 4 years. But there are some cases where that 4-year maximum term does not apply, and that is where the contracting authority considers the nature of the goods, services, or works to be supplied. The call-off contract to be awarded under the framework means that a longer term is required. That's great. What exactly does that mean? Hopefully, the guidance gives us some examples of what sort of scenarios might make a longer term justifiable. So number one is where you've got a large construction or infrastructure project where there are a variety of call-off contracts are awarded under a framework throughout the life of a development. So say, for example, you had some sort of city centre regeneration project if you were a council, or maybe some, house building project if you were a housing association, and that was going to take place over, 6 years, 8 years. In potential, you could use that 6 or 8 year term if they're all going to be interrelated. That development could form the basis for your estimated duration of your framework. Another example is of where you can have more than 4 years suggested by the guidance is where the upfront investment by a supplier to deliver the call-off contract, for example, IT system development, where the return on that investment would require call-offs to be awarded over a longer term. And that could also potentially be the case, something just thinking aloud, but see, for example, electric vehicle charging points or something like that. Anything where there's a bit of an upfront investment from a supplier, it may be a case where you can justify that if you want a longer framework. But do make sure you're recording your reasons and you've got a legitimate, reasonable rationale why you're having it longer than 4 years. And finally, then there could be one where the funding cycle for the project exceeded the maximum term, assuming the development of the project to be provided under the framework was tied to the funding cycle. So say, for example, you were getting government funding towards a particular project, and that government funding was going to be over a 10-year period. Potentially that might be a basis to award a longer term framework. But obviously you don't have to, you may decide for other reasons you just want to have, traditional 4-year frameworks, or shorter, whatever you consider appropriate. But that flexibility is there, folks, if needed, if you did want to have a longer framework. What about the award process for call-offs? So this isn't the awarding the framework, because awarding the framework itself is very much just like a normal procurement. You can either use your open procedure, or under the Procurement Act, you can use your competitive flexible procedure, which, in theory could involve weird and wonderful things like dialogue, negotiation, site visits, presentations, etc., etc. But anyway, so we've done all that. We're now moving on to look at the actual call-off awards from the framework. We've set up the framework already. So when we're awarding call-offs, we've got 2 choices, folks. Number one, we've got direct award, not to be confused, of course, with direct award, no competition, but rather direct award from a framework that has been competed. Because we're making a direct award from a framework, we don't need to publish a transparency notice. If we are making a direct award where there's been no competition, we need to publish a transparency notice, and we need to satisfy one of the direct award grounds. So, extreme and unavoidable urgency, etc., etc. So important to make sure people within the organization are clear on the difference between a direct award and a direct award from a framework. Typically, a direct award from a framework creates much less of a headache. But anyway, if we are awarding call-offs, then we've got 2 choices. We've got number one, we've got that direct award. Number 2, we've got a competitive selection process. In plain English, that is a mini competition, or mini comp if you're one of the cool kids. I'm not. So that is the 2 choices. You can also have a mixture of both. And I see that quite commonly. What sometimes is for lower value awards in particular, there maybe more of a steer towards being able to make direct awards. For higher value call-offs, there may be more of a steer towards having a mini comp, but that's not exclusive. There are all sorts of different combinations, and sometimes it's just left at the discretion of you, the contracting authority, using the framework. But do be aware, if you are making a direct award from a framework, it's only allowed if the framework sets out the core terms of the public contract and an objective mechanism for supplier selection. So there must be some sort of objective mechanism for supplier selection. So that could in theory be something like a ranking, could be a ranked framework, or sometimes, the first ranked supplier, they get the award. If they turn it down, the second ranked supplier gets it. If they turn it down, the third ranked supplier gets it, etc., etc. So kind of like a cab rank rule. Or alternatively, you could have a rotation. Supplier 1 gets an award, supplier 2 gets an award, supplier 3 gets an award. I don't actually like that approach, if I'm being honest. I think is really ideally, I think you're going to want to give contracts to the best supplier. So if you're having, say you've got 4 suppliers and one's scored quite a bit more than the other 3, you have to give the other 3 contracts before you can come back to them again. So yeah, not a fan of those rotational frameworks, but anyway, you do have to have an objective mechanism, whatever that may be. What about pricing then? And so just to clarify here then, we're not talking about fees as in, fees that the supplier must pay the contracting authority. We are looking at the actual price payable under the contract. So if, for example, you're calling off a legal services framework, we're looking at what are the hourly rates that you are paying the law firm, etc. So a framework must include the price payable, nice and simple, or a mechanism for determining the price payable. This is interesting. This bit is new under such contracts. So it would appear, again, early days, don't have any case law, appears to be more flexible than the previous rules in terms of a mechanism for determining the price payable. What does that what might that mechanism look like? Who knows? I suppose on a simple analysis, it could potentially just involve a base price that gets multiplied by some sort of price index, retail price index, or whatever is suitable to give you an annual uplift. But I'm sure we'll see more weird and wonderful ways of determining the price payable. What I would just say is, do remember our Section 12 objectives, and one of those includes having regard to the importance of value for money. So whatever you're doing, do make sure you are able to justify that it's value for money. I must admit, I'm not persuaded yet, at least, that it's really a good idea to stray too far away from just this is the price, or this is the price subject to these annual uplifts or an annual review based against a particular index, etc. But it will be interesting to see though what mechanism for determining the price payable we see over the years. I do sympathize with contractors. Obviously, over the past few years, we've saw a lot of fluctuation. All the things in the world happening when you turn off the news, that can feed its way into supply chain costs very easily. Thinking things like Trump's tariffs, etc. So it is difficult. You should think carefully in terms of asking suppliers to commit to a fixed price, and that's absolutely the sort of thing you should be, floating at pre-market engagement stage. It will depend on the particular market, but I think particularly where you are buying things where there is a supply chain involved, and that supply chain can be subject to fluctuations and spikes in demand and other issues, perhaps maybe things like fuel prices. I would just think carefully about requiring a fixed people. But that's a legal position. You need to either have the price payable or a mechanism for determining the price payable. But as I say, if you're having a mechanism for determining the price payable, please, please, please do make sure that is clear, and don't forget the need to justify that we are having regard to the importance of value for money. And some of you on the call will also be subject to separate duties regarding value for money. Also, for example, in local government, anybody on the call will be subject to, the duty of best value as a best value authority, a council. So you need to be able to justify that you're getting plenty of bang for your buck. What about users then? Who can use frameworks? The tender notice must identify all contracting authorities that may award call-off contracts under the framework during its term. This can be done either by listing the names or by describing categories of authorities. For example, all local authorities within Norfolk, or all central government authorities as defined in the Procurement Act 2023, or all NHS Foundation trusts. This is interesting because actually this is quite wide when you think about it, because if you think of all central government authorities as defined in the Procurement Act, you're covering all sorts of organisations. So, and you'd be surprised some of the organisations who are deemed to be central government authorities. So, yeah, bit surprised by this. I think this is possibly more vague than I would have anticipated in terms of who can use frameworks. But yeah, just something for you to bear in mind. And as we'll come on to later, you also need to, when the shoe's on the other foot, when you're the person using the framework, not setting it up, you do need to make sure your organization is described within this class or category of contracting authorities. You need to see there, does this say, housing associations in England, or councils in the north of England, or all local government in England, or etc., whatever it may be. But make sure you can point to something that says, yep, that's us, we're covered. What about the debrief requirements then under the Procurement Act? The guidance states that assessment summaries are not required to be provided to suppliers following the award of a call-off contract. So quite similar then, folks, to the previous rules where you didn't need to provide a standstill letter to losing bidders on a mini comp, or Alcatel letters for anybody in the call who really wants to show their age and feel old. Apologies for that. So yes, bit like the previous rules, you're not entitled as a losing bidder in a framework mini comp to the full sort of juicy debrief. But it does say contracting authorities are encouraged to provide them as a matter of best practice, not a legal requirement. But yeah, I think you would need to take a view on this. I would certainly look at the framework value. And I mentioned earlier that OCS case, that was a case where the bidder was not provided with a debrief, but it was found that, they were not provided with sufficient reasons in order to discharge the authority's obligations under procurement law around things like, transparency, equal treatment, etc. So I would just be wary of being short and sweet with debrief on frameworks, particularly on higher value awards that may be more susceptible to challenge. So I don't think that's necessarily bad advice to still give people an assessment summary if, for example, you're running a £1 or £2 million mini comp on a framework. And again, it's a voluntary standstill when you're calling off a framework. It really depends, folks. There are a myriad of factors you need to consider in terms of, what's the risk? How quickly do we need to make the award? How long have we got? But I would generally err on the side of caution if you can, and it doesn't harm to run that voluntary standstill period, because one of the benefits of running that voluntary standstill period also is it gives you a chance to flush out if there's been any mistakes. And it does happen. I've seen it, just either arithmetic errors and people adding up the numbers wrong, particularly in more complex procurements. So at least if you've got a voluntary standstill period, it's not a case of people writing in and saying, by the way, those numbers are wrong, and you thinking, oh, that's great, we signed a contract yesterday. So it does just have that sort of cooling off period. And also I think, it can, at least where you stand. Usually if someone's going to bring a legal challenge, you'll hear about that quite quickly. So, you usually get a rumbling within days if someone is going to make any mischief. So at least you know where you stand before you are actually entering the binding contract. Although there are pros and cons, it's not necessarily a straight. And remember, you must publish the contract award notice before award, but again, only for above threshold call-offs, because you don't have to publish a contract award notice below threshold, whether that's on a framework or off a framework, that award. And then remember that if you Once you've concluded your framework award, then once you've entered into the call-off contract, you also need to publish the contract details notice post-award. But remember, again, there are financial limits or financial thresholds around when that applies. And do remember that there are notifiable below threshold procurements. So it is a bit confusing, but you wouldn't try and make it more simple. Would be good. You shouldn't need to publish a contract award notice for a below threshold call off, but you might need to publish a contract details notice for a below threshold call off if it's a notifiable below threshold contract. So say, for example, you're a council or housing association and you're placing a call off contract worth 100k. That's a notifiable below threshold procurement. So you shouldn't need to publish the contract award notice because it's below threshold, but because it's 100k, you should need to publish a contract details notice because that's above the 30k threshold. Hopefully that makes sense, but if not, it's worth just getting yourself familiar via the guidance with the rules about notifiable below threshold procurements. What about liability then? Where does liability sit for all of these things? Who's liable for setting up the framework? Who is liable for calling off framework? Where a centralized procurement authority has set up the framework, the guidance says the centralized procurement authority is responsible for complying with the Act when setting up the framework. However, the contracting authority procuring under the framework will be responsible for complying with the Act when carrying out a procurement and awarding a call-off contract under the framework. What does that mean in plain English? CCS set up a framework, that's their problem, that's their issue, they're in charge, they're responsible. You come to use that framework, other frameworks are available. In the years following that, that's on you. That's on your council, that's on your housing association to make sure you are complying with the public procurement rules when you are using that framework. What about then where you are using a framework that is set up by another council or another housing association? The guidance is a little bit more muddy, I think, in that case. So here's what it says. Try and read this slowly, see if I can make sense of it. Last time I read it, I was struggling. Anyway, for setting up frameworks that other contracting authorities can use, then contracting authorities cannot delegate any part of their obligation to comply with the Act and remain fully liable for any unlawful award made by them as a consequence of the arrangement. Made by them, who is them. In terms of frameworks established by contracting authorities for use by itself and other contracting authorities, this means that the contracting authority procuring under the framework must be satisfied that the framework itself complies with the Act, as it will be liable both for compliance with the Act when establishing the framework and when carrying out a procurement and awarding a call-off contract under the framework. What a mess. Is it just me, or is that very difficult to make sense of? Definitely written by a lawyer. Anyway, as to say, less clear cut, long story short, I think though there is certainly the potential for there to be a problem. So what I would say is if you are setting up a framework, it's not necessarily clear cut that you would be off the hook. I expect the liability will principally sit, like the CCS example, with the contracting authority using the framework, but that wording is a bit grey and woolly. So do just be aware also that even if you set up a framework and someone else uses it and they get a legal challenge, they may get the legal challenge, but there's still potential reputational risk to you if someone's saying, ah, yes, that's Manchester City Council's framework, or oh yeah, that's Anchor Housing Group's framework that happened on. So do just be careful of the reputational risk. What about light touch frameworks then? So just to clarify, a light touch is things that are subject to the light touch regimes. So, education, social care, say certain legal services, things like that. This continues to attract less strict procurement rules. There is no maximum length in this case. So you could set up, for example, if you were a local authority, you could set up a social care framework that could be 6 years long, it could be 10 years long, if you're able to justify that for other reasons. It could be as as long as you like it. There is no maximum length under the Procurement Act. There's also more flexibility around the mini process. See Section 46 Act for more on that. For example, there's scope to change award criteria at the point of call off rather than simply refine it. And award criteria, just to confirm, that's our commercial and non-commercial factors traditionally, so things like price, quality, etc. Usually articulated as a percentage of available marks. The modification rules do not apply to light touch contracts, including frameworks. So as I say, we've covered that last year, and we'll come back to it in some of the sessions in this series about the rules on contract modifications. But those rules do not apply to light touch regime. But again, do remember the Section 12 objectives must be had regard to the importance of so things like, you know, acting with integrity, sharing information with suppliers, etc. So that's something to keep in mind. You don't necessarily have an entirely free rein in terms of awarding a light touch contract and then fundamentally changing it. You know, that could potentially be arguably in breach of you know, some of those objectives that you're supposed to be having regard to. But there is considerable scope to modify a light touch framework. So, for example, additional services to extend the length of term of a light touch framework that's, you know, performing well for everybody, etc., etc. Folks, I'm conscious it's just gone past 11, and I did promise we would have a break. Let's see everybody back here, please. At we'll start again at 8 minutes past 11. So 8 minutes past 11. If you want to stretch your legs or grab a drink, we'll see you back here at 8 minutes past 11. Thank you. We will get cracking again in a moment. Thanks. I was just having a look there at some of the audience questions coming through. So some really good questions. Thanks for those. Please do feel free to fire across any more. We should have some good time for questions at the end, and I will run through those questions so far. So some good ones there that definitely had me exercising my brain during the break. So let me see, we'll just start sharing the slides again. So hopefully everybody can see the slides again on the new open frameworks. But if not, just give me a shout, seeing some thumbs up. That's good. So yes, the new open framework, folks, it's actually a bit of a misdescription. It's actually a series of frameworks in one. It's a series of frameworks that provides for the award of successive frameworks on substantially the same terms. So an open framework is actually really not just one framework, but a series of different frameworks that run into each other. This is how it works. Pardon me, 8-year maximum term for our open framework. You award the first framework, you then must award the second framework within the first 3 years. Very important, and I've seen a few people get themselves confused about that. You must open your framework within the first 3 years. You must then award the third framework within 5 years of the award of the second framework. So must open within the first 3 years, must then open again within the next 5 years. And the previous framework ends when a new framework is awarded, and there is an unlimited number of suppliers permitted. So unlimited number of suppliers. So key points, 8-year maximum term, must open in the first 3 years, must then open again in the next 5 years. Within those parameters, you can do whatever you want, obviously subject to complying with the rest of the Procurement Act. So substantially the same terms, what does that mean? Substantially the same terms requires there to be no substantial amendments to the tender or transparency notice for the successive frameworks in the scheme. This includes to the award criteria for the award of the framework. So again, our price, quality, social value weightings. What happens to the existing framework providers at the point of reopening on an open framework? Where there is an unlimited number of suppliers, there are 3 choices. Number 1, the supplier simply says, yep, I'm going to stay on the framework. Number 2, the reassessment of a tender relating to an earlier award. So they say, yep, you can score our previous tender again if you want. Or Number 3, the assessment of a new tender relating to the new framework. So they can say, actually, yeah, we'll put in a new bid, maybe refresh our pricing, refresh our social value offer, etc. Where the number of framework appointees is limited, so for example, you've said, right, we're only allowed 4 suppliers on each lot, only options 2 and 3 apply at the point of opening. So they have to do something in those cases. If there is a limited number of suppliers on the framework, they cannot just say, yeah, we'll stay on. They have to say, you can reassess our previous tender in a new tender. And we'll come on to, I think it's really, really important, folks, if you're using open frameworks, you think about all this in advance and you explain to providers, really, really important. I think contracting authorities, we have a role as educators in the market to educate suppliers. How does all of this work in practice? Lots of misinformation out there, particularly the supplier end. So that's how an open framework is meant to work. A bit of quiz time now. We'll see who has been paying attention. So I'd like you to just put in the chat, which of the following open frameworks are legally compliant? Open Framework A, it opens once a year for 6 years. Open Framework B, this opens once a year for 8 years. Open Framework C, it opens after 4 years, then closes again. It's got a total term of 8 years. Or Open Framework D, this opens after 5 years, it then closes again. There is a total term of 8 years. Cast your votes in the chat. Which of these open frameworks are legally compliant? I'll give everybody a little bit of a moment. I'm reassured so far. I think everybody's paying attention. So yes, the answer here, folks, I think is A and B. Why? Because as required, they both open within the first 3 years and they don't exceed the 8-year term. So it's up to 8 years. So 6 years is obviously up to 8 years. 8 years is within that limit as well. What is the problem with open framework C and D? Open framework C, it opens after 4 years. That's not quick enough. It needs to open in the first 3 years. Open framework D suffers from the same problem. Opens after 5 years. Do be careful on this. I was having a wee bit of a nosy last night on the Central Digital Platform in preparation for today's session, and there are some authorities who are getting themselves in a bit of a mess with open frameworks. It's clear people don't fully understand it, and I've seen it a few times now where the framework doesn't open within the first 4 years. Just to be clear, that's not compliant, and an open framework absolutely must open in a quicker time period. It needs to open in the first 3 years. So it's not a case of, which seems to be the most common error, of saying, right, we'll have a framework for 4 years and another 4 years. That is not compliant. So do just make sure colleagues are aware of that. So well done to everybody who got that right. For those who got a different answer, hopefully that makes a little bit more sense now. What about dynamic markets then? Dynamic markets are the art as previously known as the Dynamic Purchasing System, the DPS. These are a list of qualified suppliers, i.e. suppliers who meet the conditions for membership, who are eligible to participate in future procurements. Sounds a bit like a framework. A dynamic market may be split into categories referred to as parts, with suppliers only eligible to participate in the parts for which they have qualified. They can be used for absolutely anything. Under the previous regime, some of you may recall DPS could only be used for what were referred to as off-the-shelf things. So commonly used purchases, the characteristics of which, as generally available on the market, meet their requirement. So it couldn't be used for more complex, more bespoke requirements. Like a DPS, a dynamic market is always open to new suppliers. Not once a year, not twice in the first 6 years, always open. Unlike a DPS, you can now charge fees. That wasn't permitted under the previous regime. All awards must be kept via competitive tender amongst members of the dynamic market. So you cannot make a direct award from a dynamic market. You need to publish a tender notice for each award from the dynamic markets. That's something we didn't need to do last time. But this is the problem, I think. I think this maybe ties in with your question, M. Below threshold awards from a dynamic market are not permitted in England. Slight exception to this for works contracts. If you're having a works contract that is above the goods and services threshold, then that could be awarded via a dynamic market. Otherwise, you could not make a below threshold award from a dynamic market. So, for example, if you had services worth 100k, goods worth 120k, you could not make. Said to me, I think this is a technical legal term, they said, Kieran, these dynamic markets are going to be about as useful as a chocolate teapot. So yeah, looking that way so far, certainly something to keep in mind. Hopefully, I am hoping, we obviously have the consultation that closed recently, so we will, I think, be seeing some changes to the Procurement Act. Either way, I am hoping at some point this might be changed, because for now these are, a bit of a lame duck. Nobody is really using them much, but that is the rules on dynamic markets. Fees can only be charged to suppliers that have been awarded a contract. Again, like frameworks, it must be a success fee. So it has to be a fixed percentage of the estimated value. Very similar again to what we looked at earlier. Dynamic markets have their own set of notices, dynamic market notices for establishing, modifying, and ceasing or ending and closing the dynamic market. And you can have an unlimited number of suppliers. You can't change the conditions of membership during the lifetime of the dynamic market. So if, for example, you said, right, to get on this dynamic market, you need to have this level of financial turnover and this experience in your organization, you can't then change that during the life of the dynamic market. What happened to a pseudo DPS? Some of you are thinking, what on earth is a pseudo DPS? I'm hoping some of you may have came across it. Also sometimes known as a flexible DPS or light touch DPS. The pseudo DPS, folks, was a light touch dynamic purchasing system established under the previous regime. The concept is explained in some of the old Crown Commercial Services guidance. It was very popular, for example, sometimes in local authorities and used, for example, things like home to school transport. Potential problem here, I think, is there is no real equivalent under the Procurement Act. There is no express provision for a light touch dynamic market. I would suggest there isn't one. Um, and again, remembering what we've just spoken about in terms of you cannot make below threshold awards from a dynamic market, this is going to be potentially problematic. So if you do have one of these tools which you use at your authority and you know you like, your colleagues like using this, whether you can extend this before it runs out, because once it runs out, you might struggle to replace a new one. Probably the closest thing is to do some kind of open framework, but it's not straightforward, as we've just seen, and we'll see in a moment. You know, open frameworks are different to these pseudo DPS indeed markets. So it's just something to be aware of, those of you who have set up at some point one of these flexible or pseudo DPSs under the previous regime. Not so clear cut, I'm afraid, under the new rules. So what are some of the trends so far and points I think you might wish to consider? So we are seeing more open frameworks. I don't have any precise, reliable data. There has been a few reports recently. Some of you may be familiar with Tussle, who publish statistics and reports occasionally about public procurement related matters. They did an interesting one recently, which suggests that the competitive flexible procedure has only been used in something like 6% of tender notices under the Procurement Act. 6%. That seems very low. So that was quite interesting. But anyway, I didn't see that they had any statistics for open frameworks. Being a very nosy person, I had to be nosy last night on the Central Digital Platform. So I looked at the last 30 tender notices for above threshold frameworks. So the last 30 tender notices for above thresholds. I'm going to play another guessing game in the chat. I'd like people to tell me of the last 30 frameworks most recently published on the Central Digital Platform, how many do you think were open frameworks out of the 30? Harold's gone for 2. Emma's gone for 0. 5, if you can then. It was actually 9. So I was quite surprised. I thought that was quite high, certainly higher than the last time I've looked. So that's 21, 21 frameworks and 9 open frameworks of the most 30 frameworks recently advertised, and that's across the board, you know, all sorts of different authorities. But I thought that was interesting because when I looked earlier in the year, certainly it was much more in favor of, you know, traditional frameworks than open frameworks. So yeah, that's quite interesting. It's also, you know, if you ever are thinking of setting up an open framework, it's useful to just go on and have a nosy and see what people are doing, how others are setting up their openings. But do just be careful because, as I mentioned earlier, one of the things that does become clear is some people just don't really understand what they're doing in terms of, for example, it's not described as an open framework, but then halfway through the notice they say it's going to operate as an open framework. It's kind of, well, at the top it doesn't say it is an open framework, or vice versa. It says it's an open framework, but then it just says it opens for 4 years and then closes again. So it is. Emma's asked how many had got the opening dates wrong. Yeah, I didn't. I lost count. No, it wasn't that bad. There were certainly there were a few. However, so do just be careful. Some teething problems. There is a debate, I think, kind of ongoing, certainly amongst some legal practitioners, as to whether setting up an open framework is preferable to just setting up a series of closed frameworks. Why would a series of closed frameworks potentially be better? Well, you're not copying that point I mentioned about them having to be on substantially the same terms. You could set up a closed framework, and in 4 years' time, you could actually think, look, we're going to change our award criteria quite substantially. You know, whatever that may be, much more emphasis on social value over price, or, whatever it may be. So that's just something to think about. But as I say, it is this new concept is gaining a bit of traction. Consider what's best for you, and I've set out a table on a later slide. Talk to the market, folks. I think particularly as the market gets more confident, more familiar with open frameworks, doesn't harm to get their view. What would be attractive to them? How are they finding the experience? Is it a bit of a pain in the backside being on an open framework, or is it quite good in terms of, a second bite of the cherry? They're not locked out for 4 years, 5 years, whatever it may be. Do explain to people what an open framework is in your tender documents. Remember, suppliers won't be familiar. And as I say, there's clearly, still a bit of confusion at buyer side. So just doesn't harm, for everybody's sake, to make sure you've got a nice, clear description of how it's all going to work. Remember that your template framework agreements may require amendment in cases involving an open framework. Even just as a very obvious point, the framework start and end dates is going to change if someone comes on at the second opening. So say, for example, you set up a framework agreement, a framework rather, and you've got your framework agreement. The framework agreement says this framework agreement commences on the 1st of January 2026. But then you open that framework in 3 years' time. When someone comes on at that point, they're obviously agreement start date needs to be 2029, not 2026. Just simple practical things like this, but there'll probably be other things once you delve into it, you just need to be careful of, in terms of you're probably going to have to tweak the framework agreement for new supplier versus suppliers who are already there. Concession contracts, mentioned these earlier, and when I give the example of the Dukes bailiffs, the local authority procuring debt enforcement services. Other concession contracts are things like, cafes, or a toll road, or sometimes leisure services. Really, it's where there's a transfer of an opportunity and a risk to a supplier, which they then utilize, and there may be some profit share back to you, there may not be. Also see concession contracts, things like e-scooters, e-bikes, these sorts of things. Anyway, one thing to bear in mind is you cannot award a concession contract from a framework or a dynamic market. And again, I've seen people come unstuck with this over the years, so do just be careful with that. If you're ever awarding a concession, that can't be from a framework or a dynamic market. Must admit, I don't really understand this rule. I'm guessing it's some complex technical point, but yeah, it's gone a bit over my head. But either way, just be wary that you can't do it. There are slightly different rules for utilities. Conscious that's not going to be relevant to today's audience. So this is the comparison table I mentioned. As I say, I'll follow up with Emma and colleagues so you get a copy of the slides. I've set out down the left-hand side some potential questions to be asking, and then that should direct you as to what might be most suitable for you. So if you look at, for example, open to new suppliers, yes or no? If so, when? If you are operating in a market where it's fast-paced, it's changing, there's rapid advancements in technology, you are going to be wanting to see, can we bring on board new suppliers? If the answer is never, i.e. a traditional framework, that might not be the model for you. Whereas you might be looking there at an open framework, or potentially a dynamic market, as long as the words wouldn't be above threshold. The other thing is then, for example, are direct awards allowed? The answer is, so say for instance, it was a legal services framework. You obviously may need legal advice quite quickly, quite promptly. Something might come up, you might need the advice that day, or at least to be setting it up in quite a rapid time scale. But you cannot make a direct award from a dynamic market, so that straight away is going to be a dynamic market out of your consideration. Again, you need to think, do we need to make below threshold awards, or might we need to make below threshold awards? So again, there, if the answer is yes, then you're not going to be looking at a dynamic market. So hopefully that's quite a helpful tool when you're sitting down with your colleagues and thinking, right, what are we going to do? And as I say, I think given the issues certainly at present with dynamic markets, I think it more often than not that is going to be framework or open framework. So the first two sections of the table. But as I say, you will get a copy of that. Hopefully it's useful. Interested then, which purchasing tool do you envisage your authority setting up most frequently? And again, just put your comment in the chat, please. A for framework, B for open framework, C for dynamic market, and just pick one. Thanks, everybody. That's interesting to see. Not too much enthusiasm so far for open frameworks. Must admit, I was quite surprised to see the increase in popularity. It will be interesting. It'll be interesting to see. Interesting times for sure. Thanks for that. So before we come back to some final points and audience questions, I just wanted to remind the point I looked at earlier about the contractual structure of a framework. So as we mentioned, the framework is made up of lots of individual call-offs, which are individual contracts in their own right. Why is that important? Say you come to terminate or novate a contract, you need to remember these are separate contracts. So you have a framework provider on your framework, they have a call-off contract, you terminate that call-off contract. Do you want to take any action under the actual framework agreement? It may depend, but potentially yes, because if you think you terminate their call-off, you then say, right, we're going to run a mini comp for a new replacement provision. Oh, hi, yeah, it's me again, provider A. You probably don't want them bidding. So do look at, is there maybe termination rights, suspension rights under the framework agreement, but that would be under the framework agreement, not the call-off contract. So do just make sure you're managing those dual contracts, particularly where things are going wrong. And then also then it's kind of, what about other call-off contracts? Suppose your authority's got 3 or 4 different call-off contracts with that provider. What do you want to terminate those contracts? It may depend on what they've done. Do just remember, it's not just the case of, and I've seen this in the past in practice, when we're working as a solicitor, it's not just the case of we've terminated their contract, we've done with them. You might have other contracts with them. You've still got the overarching framework agreement. Do just keep that in mind. Do also remember to bear that in mind for things like novation. And novation, just to recap, is a 3-way agreement where you replace one of the parties in a contract. So typically in this context, you've got the contracting authority, you've got the provider, and then you've got the new provider. So sorry, you've got the contracting authority, an outgoing provider, and an incoming provider. So those would be the 3 parties to the novation. So say, for example, framework provider A wants to novate to company B following a corporate restructure. Along with novating the actual framework agreement, you would need to novate any individual call-offs, because again, framework is a contract, each individual call-off is a separate contract. And this is again another one I've seen councils and others get themselves in a bit of a sticky position with by not really following through and covering all the contracts rather than just one of them. So before we move to question, folks, I'm going to run through some of my top tips. I'm going to start with top tips with calling off, because that's probably, for most of you, I would imagine that is your most frequent experience, your most frequent role when dealing with frameworks. First thing we need to do, check whether PCR 15 or Procurement Act rules apply. You need to be, hopefully it's usually fairly clear. If not, and I think unfortunately in future it will become less clear, because say come 27, 28, you might be thinking, actually, is this Procurement Act? Is it PCR? You need to be kind of going back and thinking, when was the actual tender notice published? So yes, do check whether PCR 2015 or Procurement Act rules apply. And do also, if you are calling off your own framework, do try and put in place some system where you can color code or coordinate it, so people aren't going to have to check every time, all delving through old records to see when the tender was advertised. The first things first, Check whether is this a Procurement Act framework, is this a PCR 2015 framework. That will dictate the rules legally that apply. Check a bona fide contracting authority has established the framework. For example, is it a local authority, a housing association, centralized procurement authorities such as CCS, etc. Check you admitted user. Does it say somewhere in that, name, Liverpool City Council, 123 housing, or does it in associations in England, or all housing associations in the northwest of England, or all local authorities in the northeast of England, whatever it may be? Do just make sure there's something that somewhere there you can hang your hat and say, yep, we can use this one. Check your needs are within scope. Really important. It may be an IT framework, but it may not be the type of IT that you are buying. Again, it could be a legal services framework. It may not be the type of legal services you are actually purchasing. So just make sure your needs are within scope. You should be able to see the specification if you have those around. Do check whether the maximum framework value has been exceeded, particularly if you are making awards towards the end of the lifetime of the framework, and in particular if you're making a high value award, which may be more likely to tip it over the limit. And also then higher value contract awards generally more likely to attract a legal challenge. Check the call-off terms and conditions are acceptable. As I say, don't just always rely that they're going to be fit for purpose, because I've seen it over the years that they aren't. So do check things like, liability caps, indemnities, etc., etc. And if you are going to run a mini comp, it's not necessarily a straightforward area of law, but if you are going to run a mini comp, typically you've got a bit more scope to change things. So you may have a bit more scope then to say, actually, we're running a mini comp, but we are changing the liability cap, or we're changing the indemnities. And then at least that way people have the ability to bid accordingly or not bid. Check how call-offs are to be made. Is it a direct award? Is it a mini competition? Is it a mixture of both? And then apply that to your specific circumstances. And again, sometimes that may be based on the particular value of the award you want to make. Ascertain what role the framework operator will play. Sometimes they're a help. I have come across a few cases recently where they've been nothing but a hindrance. Do ascertain what role the framework operator will play. Keep them on a tight leash would be my advice. I did see one recently with a client I was working with, and basically the framework operator was just sending out letters on the council's behalf, and someone complained that the letters weren't very good to begin with. Anyway, someone complained, and the framework operator wrote back without consulting the council and said, oh, sorry, you're not happy. Could you tell us more about why you're not happy? I'm just like, why would you do that? Why would you really invite someone to send you inevitably then a long rambling rant threatening legal action? So do just keep them on a tight leash. I would generally try to retain oversight of the correspondence. Again, that's your call off. Someone brings a legal challenge, it's going to be against you. So me personally, I wouldn't have framework operators sending out letters that I hadn't seen. Emma says, EM Procure always try to be helpful. That's good. Helpful rather than a hindrance. That's our motto. So yeah, do just joking aside, do just ascertain what role the framework operator will play. If you have any concerns about the role they are playing, do just have that honest but diplomatic conversation in terms of, look, as happened in that case, can you make sure you're running everything past us in terms of your correspondence with suppliers on our behalf. Give adequate reasons to any losing bidders in a mini competition. Again, typically the provision of reasons under public procurement law has been very important. I don't think that will go away under the Procurement Act, so do just give adequate reasons. I probably would err on the side of giving a similar level of reasoning than you would give if it wasn't a framework mini comp in terms of the new assessment summaries under the Procurement Act. Ensure the call-off price is the price or the pricing mechanism from the original framework. And again, do be aware of the telltale signs when someone's saying, oh, no, just finalizing price, or we're just having a discussion about price. I'm kind of like, well, do we not know the price? Is that not the whole point of a framework? If there's an order form, run it past your legal team. Again, that's legally binding, folks, like any other contracts. Don't feel that should just be left on your desk as a procurement officer. I would certainly be getting legal input, again, particularly for those more complex, more detailed and or high value order forms. And do remember your new notices under the Act. You need to publish a contract award notice pre-award and a contract details notice post-award. But again, just remember, contract award notice is only for above threshold procurements, and the contract detailed notice will either be for above threshold procurements or notifiable below threshold procurements, which is for housing associations and councils is above 30k. So yeah, long story short, you'll probably be publishing quite a lot of contract details notices for call-offs. Whether you're publishing contract award notices will depend if it's above or below threshold. Moving on though, then to those scenarios where you are setting up a framework, check which authorities might want to use it and get a feel from them how much they're going to spend, because remember, you have to estimate and you want to get that estimate right because of the problems we mentioned about exceeding contract value. Clearly describe other potential users. Is that, again, housing associations in a certain area? Is it a list of people, our members whose list can be found on our website, whatever it may be? Be careful not to underestimate the value. For other users, try to get an indication again of the frequency and value of their call-offs. Consider creating and issuing a user guide. Always find that really helpful. Consider creating and issuing a template order form and possibly even a template ITT for many comps. Again, it can just keep people on track. Get appropriate terms and conditions, both for the framework agreement and the call-offs. Set out clearly how call-offs are to be made. Are you having direct awards? Are you having many competitions? Are you having a mixture of both? Are there particular rules which dictate when each can be used? For example, values up to a certain amount, you can do direct award, values above, you can't. Just give it some thought and make sure it's clear to everybody, and ensure your price or pricing mechanism are clearly set out. Final thoughts then, folks, before we turn to questions. Framework agreements likely to remain popular, but do just exercise caution. Call off from a framework is subject to a legal challenge, just like any other procurement. So again, I think traditionally there's been a wee bit of laxness has crept in with some frameworks. Make sure that isn't yourselves. Do consider, on a practical level, implementing internal processes. I think a checklist is a great idea. Hopefully today's slides might help you if you did want to put something like that together in terms of establishing or calling off frameworks. And I think dynamic markets are unlikely to be used by housing associations or local authorities on any kind of wholesale basis. Do just make sure your colleagues are aware of the restriction on below threshold awards. So yes, thanks very much for listening. I know many of us are connected on LinkedIn already. If not, you're very welcome to connect on there. That's also my contact details if you'd like any to explore any potential training or speaking at events, conferences, etc. You're very welcome to get in touch, and always happy to provide a no obligation quote for any procurement law training needs. This is the first in our 6-part series, so hopefully we'll see you again at some of our future events, but we've still got a bit of time, and I'm now going to pick some questions. Would you like me, one moment, would you like me to take some questions live, or go back and look at the ones that have been put in the chat?
It'd be great if you could take some live, if that's all right, please.
Yeah, no problem at all. So would anybody like to ask a question? You're welcome to, it can be a new question or it could be one you put in the chat earlier.
Come on,
No such
everyone,
thing.
be brave.
No such thing as a stupid question, and believe me, I've heard worse. Tell you what I'll do in the meantime, I'll pull up some of the questions from the chat, if that's okay.
That's fine, thank you.
So one of the questions was, can the call-off go beyond the end of the framework? Yes. So just to clarify for anybody what exactly I mean by this, if your framework ends, say you have a framework that ends at the end of December 2025, could you make an award this month that lasts for a year? And then, because when you think about it, then the framework would end in December, the call off would end next October. Yes, I think that's perfectly fine. Are there any limits or best practice for duration of call offs, i.e., on the final day of a framework, if a call off is awarded for a period of 4 further years? Conduct it yourself, there was some other breach of procurement law. It maybe doesn't look great, particularly if it was like 4 years seems quite a long period for a call off. So it will depend on the specific circumstances, but do be aware, obviously, that we operate in quite a visible environment. A lot of people on the call will be subject to things like freedom of information, etc. So things can come out in the wash. You can also be audited, as we've seen, particularly with some councils over the past year. Their auditors on their procurement function haven't always been terribly complimentary. So do just be careful. I think can you justify it would be the question I would look at. Or does it feel a bit, it feels a bit, maybe you shouldn't be doing it. But if you can justify it in principle, there's nothing that would prohibit that. There's no sort of long stop date by which you must have any call-offs must have ended. Can suppliers increase prices during the duration of the framework? Give you a typical lawyer's answer. It depends. I think it's really would look back at what does the initial framework say. In particular, is there a mechanism for a pricing uplift, which sometimes there is. Again, that may be eminently sensible over the past few years with some of the volatility we've seen in the global markets. I think it really depends. If the contract does not provide for them to increase prices, then it is a question of looking at the modification rules. So if someone has, you have awarded someone a contract and they turn around and say, look, we want a bit more because this isn't sustainable, you are then looking in, if it's a framework under the previous rules, you are looking at Regulation 72 in terms of, is this a permitted modification? It probably will be, depending on, so long as the price increase isn't, extraordinant. But you do have to be looking at that. If the framework allows amendments to be agreed between the entities to standard terms, surely minor amends are allowed to call off contracts. Yes, I think, again, if the framework allows it, if that's the crucial point, it's looking back each time at, what does the framework agreement say? It's a really good starting point for us always is to be looking back, what did the original procurement say, and then allowing that to inform us. But it's also just making sure then that there's sufficient clarity on that in terms of what is permitted to change. Because again, more detail in Regulation 72, but it does need to be set out with a certain level of precision what changes are allowed. I've been asked by my non-procurement colleagues, sounds ominous, how long PCR 2015 will run alongside the Procurement Act. For now, I've said the February 2029 cutoff. However, in theory, could a PCR framework in, say, January 2029, there could then be a 4-year contract in effect to run to 2023. So yeah, I think the February 2029 cutoff, my understanding was that related to DPSs. Dynamic purchasing systems. So I'll double check that. It's a good question, but I wasn't aware that there was cut off on frameworks. But as I say, I will double check that. But similarly, even the February 2029 cutoff did extend to frameworks that, like the example we've just looked at earlier, that wouldn't stop you making an award in January 2029, again, provided you were able to justify that that was all above board. But if the tool is open, then you can use it, because otherwise then there'd be no point saying, oh, well, you can have these tools until February 2029, but you can't be using them in the months immediately before. It just wouldn't make sense. So yeah, I think that they're still going to be open right up until the end. But if you're making big awards right up near the end, do just be aware that that mightn't look great. So make sure you're comfortable with doing that. I'm sure you'll get to this, but for dynamic markets, are they still not to be used for under threshold procurements? Yes, we did get to that, and the answer remains no, they can't be used for under threshold procurements in England. The exception to that is works contracts. You can make an above threshold, sorry, you can make a below threshold works award through a dynamic market, but it would need to be above the threshold for goods and services. So, for example, to give a practical example, you could have a works contract worth £1 million awarded via a dynamic market. Because whilst that's below threshold for works, it's above threshold for goods and services. Otherwise, general position, below threshold awards aren't allowed. So you couldn't, for example, make a 50k services contract award from a dynamic market. I think we've settled on referring to standard rather than closed frameworks. Yep, that works. Do frameworks still have the restriction of not awarding to two contracts? I think it was worded something like one or more than two, i.e. three and more. No, don't think there's any, not aware of any restriction in that regard. Can excluding a supplier lead to a legal challenge? Will it delay awarding a call-off? Potentially. I think it depends on in terms of, you would need to be confident, have they met I'm presuming this relates back to the exclusion ground, although it could be a contractual exclusion in terms of, or sometimes more so a suspension on a framework. It could lead to a legal challenge. It would be ultimately a case of, taking legal advice in advance. Do you think your position is defensible? Will it delay awarding a call off? It might. It depends again, are they going to take it further? And remember, you don't have to have a standstill for the call off. So if, for example, you weren't having a standstill, then there would be nothing in theory to stop you pressing on. But if you knew there was going to be a legal challenge, you would have to weigh that up carefully in terms of the pros and cons. So yeah, but yeah, most things could potentially be subject to legal challenge. It's just whether you think you'd be able to defend it or not. Thanks for the chuckle a few weeks back. Oh, that was a photo of one of my memes. Yeah, if you don't follow me on LinkedIn for procurement law, there are also some procurement memes, which are probably better in fairness. If a standard framework is provided with a duration exceeding 4 years and reasons are given, but these are not challenged, would future call-offs in years 4+ be at risk of challenge given the original date of knowledge, assuming the challenge relates to the validity of the framework duration? Really good question. So I think essentially what this is getting at is, say, for example, you say, right, we're going to have a 6-year framework and nobody complains, and you come to year 5 and you go to make an award and someone says, hold on a second, you weren't allowed a framework more than 6 years. I would say by that point it's time barred, because under public procurement law, it can be extended, but you've generally only got 30 days in most cases to bring a legal challenge if you're a provider. So if they were not happy with the framework length, they would have needed to do something about that at the time. Because they haven't, I think if they were to come in year 5 or year 6 or whatever it may be, I think they would be time barred. I'd be fairly confident on that. So yeah, really good question. Can direct awards under frameworks be done due to urgency? There's not time to do a mini competition. Is this advisable? If does the framework allow for direct awards? If the answer is no, then I wouldn't do one. If there is urgency, then you could make, provided that was, you're able to justify the urgency grounds, you could just make a direct award full stop out with the framework, and there'd be nothing to stop with you, agreeing similar terms and conditions or similar terms and some similar pricing as the framework. But if the framework did not allow direct awards, then I wouldn't necessarily see urgency as a reason to override that. But again, if there was genuine urgency, you may be able to make a direct award in the first place and not need to go through the framework. But I would always use frameworks the way they've been set up to be used, and I wouldn't necessarily let urgency throw me from that. But again, you could structure your direct award to look whatever way you want it to look, subject to being confident you've satisfied the grounds and under the new rules that you're publishing the relevant notices, etc. Could a mechanism for determining the price payable be obtaining quotes from all suppliers in a lot? Possibly. I'll have to see what happens with this. I suppose it's just we have to remember that under procurement law, we have to award to the most advantageous tender, previously known as the most economically advantageous tender. But that whilst the word economically is gone, I think price is still in practice going to be very important. So it would just be my problem would be perhaps of just obtaining quotes is what if those quotes turn around and are quite high? People would just think actually we're on the framework and there's not many of us, so we're just going to quote quite high. How would you justify that also against sort of value for money? So I usually would try to restrict or limit that by some degree in terms of one thing I've seen done in the past is you can quote, but you can't exceed your quoted framework price. So if they want to offer a better price, they can, but they can't go above that price. So do just think, how are we going to keep prices low as possible? Could determining the price payable extend to as an open book arrangement with framework overheads and profits? Sounds a bit complicated and time consuming in terms of once we're getting into open book arrangements and then who's checking that and what figures are being counted and what figures aren't being counted. Maybe sounds a bit more complicated than necessarily would be my starting point, but it's an interesting thought. Did we have Let's just have a look and see if there's any more on the chat. If anybody has any other questions before we finish up, you're very welcome to pose them, whether you can come on or put them in the chat. Talking to an incompetent framework provider about a current mini comp where they failed to check the pricing at all closely in about half an hour. Good luck with that one. I am saying should have gone to EM Procure. So yes, I think that's covered most of the questions, folks. You're very welcome to drop me a quick line if there was anything else that we didn't get to. Thanks very much. Some great questions there. You're keeping me on my toes, which is always good. And I will hopefully, as I say, see you again in a few weeks' time for our next session. And then we've got in total 6 different sessions. Thanks very much for some of the kind feedback there. I'm glad you've enjoyed it. And again, yes, we will hopefully see you back in a few weeks.